So, what are some of the assessment questions you would ask next? There's two goals for assessment in this case: assess risk and try to reduce risk and prevent suicide. So, the questions on the following slides will address both of these goals. Corey et al. Outlines 5 specific pieces that you want to look for in your assessment interview, and those are listed here. And these will all be covered by the questions on the following slides. Questions to assess risk factors and warning signs. So, in the first box, these questions address known risk factors for suicide, including past history, family history, and impulsivity. In the second box, these questions further assess risk by exploring Clayton's feelings of hopelessness relative to his situation, address things like plans, ideation, and may provide directions for potential solutions. So, the second goal of assessment would be to reduce Clayton's risk and to try to prevent suicide. So, in the first box, these questions help to explore protective factors, resources, and strengths in Clayton's life to help try to keep him safe. In the second box, problem solving, here these questions could also address Clayton's sources of distress and difficulty, explore opportunities for his situation to be different, not to solve problems then and there, but there may be options and steps towards solutions that could provide some insight and hope. Finally, your assessment should also include a safety plan, consultation, and sensitivity. The safety plan should be completed before ending your first contact with him. The first bullet addresses whatever means of self harm he's discussed with you and specific actions to safeguard him. The two bullets with asterisks, reasons for living, and names and phone numbers, if he can't come up with answers for these, this in itself should guide your decision making with respect to elevating his case with crisis professionals in the community. You should also seek consultation regarding assessment questions. Experts may think of questions or support that you may not have thought of, and be sure to document your consultation. Finally, the assessment can be really overwhelming in and of itself, so it's important to provide Clayton with the utmost sensitivity and compassion in your demeanor, how you word the questions, and how you address his situation.
As both an ethical and legal obligation, counselors must obtain informed consent. During intake sessions, counselors should take the time to explain confidentiality and its limitations, explaining it enough for each and every client's understanding. They have a right to know how their information will be protected and when confidentiality may be broken. Ethically, our responsibility goes beyond simply reading a form or a script. We need to make sure the client truly comprehends confidentiality and that may need to have adjustments based on cultural backgrounds. Ethically, counselors must stay up to date on training throughout their career, including suicide prevention training. If an ethical dilemma occurs, counselors should seek consultation from supervisors or colleagues instead of relying on personal judgment if the situation is not as simple as it seems. In Clayton's case, he has mentioned multiple warning signs that is a part of the suicide risk assessment. Take a look at page 274 to 275 from our Issues and Ethics textbook. Clayton has said verbal warnings of thoughts of suicide. He has access to a lethal weapon with his gun that he has already taken out once, which also means we can assess impulse level. He may be experiencing depression due to hopelessness because of his never ending pain. He has a history of alcohol dependence and prior drug abuse. There are more signs in his case. Look back on the reference and see if you can find any. Ethically, knowing these warning signs should be part of our training. The counselor needs to be able to manage asking direct or difficult questions to better understand whether Clayton wants to die or whether he wants relief from his pain. His therapist may be one of his only supporters. After trying to get as much information as you can from Clayton, the counselor should try to make a safety plan with Clayton. A safety plan can offer emergency resources when you can't be there as his counselor. The plan can also remind Clayton why he is important. Throughout the process, it may be ethical for the counselor to openly communicate with Clayton about making a report to maintain some therapeutic alliance.
One of our primary responsibilities is to complete a comprehensive suicide risk assessment whenever a client presents with concerns about self harm. This includes evaluating suicidal thoughts and determining the client's immediate risk for danger. Another important legal responsibility is understanding that confidentiality has limits. While protecting client privacy is one of the foundations of therapy, California law recognizes that protecting a client's safety comes first when there is a serious risk for self harm. In these situations, therapists are legally permitted to take reasonable steps to protect the client, even if that requires limited disclosure of confidential information. These decisions should always be based on sound clinical judgment and use the least restrictive intervention necessary to maintain the client's safety. Finally, accurate documentation is a critical legal responsibility. Therapists should carefully document the suicide risk assessment, the client's statements, clinical observations, consultations, safety planning, referrals, and the rationale behind every clinical decision. Thorough documentation demonstrates that the therapist met California's standard of care while fulfilling both legal and ethical responsibilities. Ultimately, our responsibility is to balance the client confidentiality with our duty to protect life and promote client safety. If I were Clayton's therapist in California, my first legal responsibility would be to conduct a thorough suicide risk assessment. Clayton presents with several significant risk factors, including chronic liver disease, ongoing physical pain, feelings of hopelessness, and social isolation, access to a firearm, and recent suicidal thoughts. The most concerning detail is that he recently removed his gun and examined it, which suggests his suicidal thoughts may be becoming more serious. Under California law, therapists have a legal and ethical responsibility to protect clients who may be at danger to themselves. While confidentiality is one of the foundations of therapy, it is not the absolute. California recognizes an exception to confidentiality when a client presents a serious risk of self harm, allowing the therapist to take reasonable steps to protect the client. My next obligation would be to determine Clayton's level of risk by asking direct questions about suicidal thoughts, whether he has a plan, his intent to act, access to the firearm, and any previous suicide attempts. I would also assess protective factors, including his AA sponsor, participation in recovery meetings, substance abuse, his substance abuse counselor, and relationships with his adult children. If I determine Clayton was imminent risk of suicide, California law allows emergency intervention through a 5150 psychiatric hold, where a qualified professional or authorized peace officer may arrange for him to be evaluated and hospitalized for 72 hours if he is considered a danger to himself. If the danger continues after that evaluation, the hold may extend under the California law.
Steps in ethical decision making. Everything I will be referencing is to the issues in ethics and the helping professions by Corey G. And there are three important things to take into consideration when it comes to having the steps in ethical decision making, and that's it's not linear. Emotions and cultural context and the client collaboration all play a role, and documenting the process is important, and so that you can be able to question it later on, and also that including the client is very helpful in the process whenever it is possible, so that they can be able to see that their actions, why it happens, and what they can do to prevent them. The first step is to identify the problem and ask what is the root of the dilemma, who is involved, and what can be at stake, right? And in Clayton's experiences, he has severe chronic pain, feelings of hopelessness, and suicidal thoughts. And one of the big major signs is when he took out his firearm and examined it. And I think as a therapist, that is the challenge of being able to balance the autonomy and confidentiality for Clayton. And it's our responsibility to protect him if there is a risk of him taking his life. And, you know, that part of the three things is determining whether the situation is ethical, legal, clinical, cultural, or all of the above. And you want to be able to, our goal is to gather all the information of the situation before drawing any kind of conclusions. Step two would be to identify the potential issues involved. Clayton values independence and his ability to make his own decisions, which would be autonomy. His access to a firearm increases the risk of self harm if no action is taken. That is non maleficence. As a counselor, you may need to see what is best for his interest, even if that means limiting confidentiality, which is beneficence. And as a counselor, you should be honest about ethical responsibilities, which maintaining trust, which is fidelity, and Clayton's isolation, retirement, and chronic illnesses increases overall suicide risk. This is something to be taken into consideration. Step three is to review relevant ethic codes. The AAM-MFT Code of Ethics requires counselors to take reasonable steps to protect the clients from imminent harm. The ACA 2014 Code of Ethics, where counselors are expected to engage in careful ethical decision making when facing dilemmas. Both of these codes permit, breaking confidentiality where if there's a risk of the client harming themselves. Step four is knowing the applicable laws and regulations. Most states allow or require breaking confidentiality if there's a risk of self-harm. A firearm is a safety variable in the situation, so restricting access under state applicable law is important. And also now step five would be to obtain consultation, and you don't have to make these decisions alone. You can consult with a clinical supervisor or senior colleague, and also Clayton's pain management team since they have context of his previous history. And if legal risk is unclear, consult with the agency's legal counsel or the licensing board ethics line. Act, weigh, and follow through. Step six would be to consider courses of action and brainstorm a lot of options, one of which could be safety planning, which would be no harm agreement, and option two would be firearm restriction, which in his case would be a little difficult because now this breaks trust in Clayton's case. Another option is psychiatric referral. The family would sponsor, the sponsor would consent, and also involuntary hospitalization, and that is a risk and imminent if he does not cooperate. Uh, you also have now step seven to consider the consequences. Um, Clayton's case application, a safety plan alone may build trust, but it may not be enough since he still has access to a firearm. Um, Restricting the firearm cuts immediate risk the most, but obviously in Clayton's case, it involving family may increase support, but after it may affect his sense of independence, and involuntary hold may be necessary to protect Clayton, but it can ruin trust. And step eight would be to implement the best course of action. Conduct a comprehensive suicide risk assessment. Suicide risk is not one-time determination. It's something you must follow up in 24 to 48 hours, and also monitor a safety plan's effectiveness by also consulting with colleagues and refer Clayton to a psychiatric evaluation.